Welcome to another edition of Question and Answer with a Criminal Defense Attorney. I am Mark Solomon, a defense attorney in Denver, Colorado, and today's question is about DUI. But before we get to that, don't forget to click like on this video if you're enjoying it and subscribe with a little bell next to it to be notified of future videos. So DUI and DWAI. If you're not from Colorado, the DWAI is for driving while ability impaired. And both DUI and DWAI require two elements for them to prove. That is either impairment or intoxication, which I'll talk about in a minute, and operation of the vehicle or actual physical control. So intoxication and impairment are two very different things. I've been in many DUI trials, and a lot of people, including judges and prosecutors, tend to use the terms interchangeably, but they are very different. You can be impaired by a lack of sleep, but a lack of sleep, while it's impairing your ability to drive safely, is not a DUI. And the same thing, you can have had some alcohol, like a beer or a glass of wine, and not be impaired. I would never recommend that. You can be willing to bet if you smell like alcohol and you're stopped by a police officer, you will be facing some kind of at least inquiry into whether or not you were driving while impaired. So the things that they have to be able to prove on that level of impairment looks like this. People talk about the threshold for driving drunk. And while there isn't really a threshold, there are some limits that they set. 0.05 alcohol by blood or breath, you will face a presumption in trial that you are impaired because of the alcohol in your system. If your blood alcohol or breath alcohol is a 0.08 or more, there will be a rebuttable presumption to a jury that you are substantially incapable of driving a vehicle safely. And if the jury believes that number and that presumption, you can be convicted. That's why people call it the limit. But again, it's a limit for the presumption that gets introduced in trial, and that's it. But it makes things difficult. And if you've had if your BAC is a 0.08, then chances are you've had at least 3 or 4, 5 drinks. So that is, in my mind, something that a normal, average, everyday juror is going to find that you were impaired if your BAC is as high as that. So be aware of that. So what are the penalties? And the answer is it is gradated based on whether it's a DUI or a DWAI. Every single one of these cases has jail, fine, community services, alcohol classes, and probation, plus a license suspension, which I'm not going to go too much into here. I have done that on other videos, which you should look at. But jail for a DWAI is up to 180 days. Jail for a DUI is up to 365, a year in jail. The fines are up to $500 for a DWAI and up to $1,000 for a DUI. The community service has a mandatory minimum 24 hours for the DWAI and 48 hours for the DUI. And then you have what I think is the most onerous part of trying to get through a DUI probation, and that is the alcohol classes and treatment. Let me be clear. The alcohol classes take 12 weeks. The treatment, which on a first offense is either a track A or B therapy, often depending in the jurisdiction whether, what your BAC was at the time of the test. But what they try to do is an alcohol evaluation, and they're trying to find out what's your level of involvement in your life with alcohol. The higher the involvement with alcohol, the more likely the defendant facing a DUI probation will get a higher level of alcohol classes and treatment. In other words, instead of track A for a first, you'll get track B. On a second DUI, a lot of people are much more likely to get track D therapy, which, as you can see, that is 86 hours of classes, which is 2 hours per week. Do the math, that's a long time to take a class. However, sometimes if the probation officer doing the alcohol evaluation thinks that the level of alcohol involvement is lower, even a second could get track C therapy. Okay, but a third DUI almost always gets track D therapy in my experience. But probation, again, first offense, typically 12 months. I've seen 18 months. Rarely first offense DUIs get 24 months of probation. But notice what I write here under jail. Often none for a first offense. But if your BAC is a .20 or more, the law does require at least 10 days of jail. And there are some judges in the Denver metropolitan area who will make you serve those days in a jail and not an in-home detention, but you would be eligible for work release, and that is something that most judges will at least consider. The last thing I wanted to talk about, since most of what I said was for first offense DUIs, is what happens on a second or third offense. And the answer to that is a second offense and third offense, both misdemeanors. However, there is no difference in the sentencing between a DUI and a DWAI. So in other words, if you go to trial on a DUI and the jury finds you guilty of a DWAI, penalty is the same thing, and that's not really a win. The penalties are different at the Department of Revenue, as in it's not an automatic suspension if it's outside of 5 years on a second. But I don't want to make this video ridiculously confusing, so I'm just going to say the mandatory minimum 10 days in jail must be served if it's within 5 years of your first offense, alcohol driving conviction in any state. On a third offense, that penalty goes up to a mandatory minimum 60 days in jail. And for both the second and third offense, you're looking at a mandatory 2 years of probation on the other end of whatever jail you served, with an additional year of jail suspended to make sure that you're compliant and don't get another DUI, especially not another DUI, during those following 2 years of following the conviction. Again, community service starts at 48 hours, and if it's important and you have a concealed weapons permit, after a second, within 10 years, you will lose your concealed weapons carry permit by law. There's a way to get it back. If that's happened to you, contact me. We can look at it and do an appeal to try to get that back, but it will be suspended upon a second conviction in 10 years. So DUIs are complicated. There's a lot of nuanced law. There's a lot of nuanced interaction between the Department of Revenue, which is the licensing authority here in Colorado, and the criminal case. Sometimes it's good to get a case through quickly. Sometimes it's really not a good idea. But prosecutors cannot lower an alcohol driving offense to a non-alcohol driving offense without stating to the court that they have no reasonable chance of winning in trial. So sometimes you get DUIs amended down to a reckless driving or a careless driving or something like that, and I've done enough DUIs to where that has happened, but it is extremely rare. So that is, and just to make sure, I always recommend not driving after having any alcohol. I said that before. I'll say it the third time. If you're going to drink alcohol, don't drive at all. Sometimes I've known friends and family who listen to my advice, and they get a lot of flack from a lot of their friends saying, it's just a beer, it's just a glass of wine, or it's just one drink. And the fact is, if you drive with alcohol in your breath and somebody gets seriously hurt, you will be facing a very serious charge. Wouldn't it be nice to know that whenever you're behind the wheel of a vehicle that has the potential to kill somebody or hurt somebody, that you did it with an extremely clear head, and you didn't do it after having just one beer or just one glass of wine. Okay, I'll get off my soapbox. It's legal advice. Anyway, that is the question and answer for today. If you would like your own question answered in a future video, don't forget you can put it in the comments below, email me, or tag me on Twitter. And as always, you have a right to remain silent. If the police officers ask you questions about what you have, what you know, or where you've been, or anything, you have a right to say, I don't want to talk to you. And if they persist, I want a lawyer.